Hi, and welcome to another edition of the Mediatwits number 163. I'm Mark Glazer, Executive Editor of Media Shift and Idea Lab. Today we'll be talking about online harassment and how bad it's gotten online, especially on social media such as Twitter, Facebook, YouTube, and other venues, and also a recent Supreme Court ruling that threw out a conviction of Anthony Alanas, who had put up threatening rap lyrics to his ex-wife and others, a conviction that was overturned by the Supreme Court this week. We'll talk about all of that this week on the Mediatwits. But first, a word from our sponsor. Running your own business requires focus. So does parenting. Mediatwits podcast sponsor NextSpace created a place where parents could give their best quality of attention to both co-working space and childcare space under one roof. Learn more at nextbase.us/nextkids. Also, MediaShift has just launched a new series of online trainings called Digital Ed. We have a great free webinar on June 17th covering how publishers can engage their audience on social media and increase revenues, led by Texas State's Dale Blasingame, sponsored by Acquia. Sign up for the webinar at bit.ly/socialrevs. So before we get into our discussion, I want to introduce our panel this week. We have Andrew Lee from American University, Jennifer Chen, freelance journalist in LA, Jonathan Peters, associate professor at journalism at the University of Kansas and also MediaShift contributor, Maeve Duggan at the Pew Research Center in DC, and our producer Jefferson Yen in LA. So Jonathan, first, this ruling from the Supreme Court that was just handed down, it seems like it's basically saying that threats that are put onto social media, online, need to have some sort of intent more than just being perceived as a threat. Is that what you take from this ruling? I mean, and it seems like it's a little bit of a shaky ruling from the way people have reacted to it. What do you take from the ruling so far?
Sure, yeah. I think to understand Alanas, it's probably helpful first to understand a couple of predicate issues. And the first is that not all threats online or offline are unlawful. The First Amendment does protect some types of threats, those that are understood to be hyperbolic or a joke. So, Mark, you and I are friends on Facebook, and if I went on Facebook and I said that, I'm going to make you watch so much Stanley Cup hockey that your head explodes, that is the type of expression that would be protected by the First Amendment. What is not protected are true threats, which reasonable people would understand as serious expressions of intent to do harm. The really difficult thing in many cases is finding the line between those two types of speech, between protected threats and true threats. So before the Alanas case, the Supreme Court had said definitively that true threats are not protected by the First Amendment. But it had left open certain issues about what constitutes a true threat. Among those open issues was, what does the government have to prove about a defendant's mental state to convict that person of making a threat under a federal threats statute? So we've known for a while that prosecutors have to prove that a threat is objectively sincere. That basically means that the audience, a reasonable person, would interpret the threat in context as an actual expression of intent to do harm. Less clear, though, has been the subjective element. So what subjective intent does the defendant, him or herself, have to have when making a statement? In other words, if I'm a prosecutor, do I have to prove that a defendant intended that the audience take a threat seriously, that the defendant made the threat recklessly, which means in conscious disregard of the risk that people might take it as a serious threat, or do I have to prove something else entirely? Those were open questions before Alanas, and as you kind of point out, Alanas didn't quite resolve all of those questions. The defendant in that case, Anthony Alanas, was convicted at trial on multiple counts in a federal indictment charging him with making threatening statements in violation of its Section 875C. It is a federal law that makes it a crime to make threats in interstate commerce. And for our purposes, that includes threats that are made on the internet. That is the interstate commerce part of it. Alanas was convicted for posting, these were to Facebook, what he characterized as rap lyrics that expressed in various ways his violent thoughts and desires regarding his ex-wife, an FBI agent, school shootings, among other things. So Alanas defended by saying that I'm not a true threatener, I'm just a rapper. I'm an artist engaging in protected hyperbolic speech. He wanted the judge to instruct the jury that in order to convict him, the jury needed to find a subjective intent, that an objective one is not enough. The judge refused to do that. The Court of Appeals agreed with that judge, so then the Supreme Court stepped in. Before the Alanas case, and this may be the most important upshot of Alanas, before the Alanas case, the vast majority of federal circuits had interpreted that law to require only objective intent, that a reasonable person would take this statement as a threat. There were only 2 circuits in the country that required subjective intent. In the Alanas case, the majority said that prosecutors have to prove something more than objective intent. And here's kind of what you were alluding to, Mark, about there still being unresolved questions. The majority didn't quite say exactly what that something more would look like. 875C is silent on that issue. It doesn't include an intent requirement. So what the court did was engage in analysis of criminal law and analysis of other criminal statutes to reach the conclusion that in order to separate innocent from bad conduct, a criminal statute always has to require some kind of bad intent. So objective intent's not enough. And so without specifying, though, what exactly that would look like, the court did say that 875C would be satisfied if a defendant transmitted something for the purpose of issuing a threat. So there it's kind of the pure intent element that you really intended for this to be taken seriously, or with knowledge that the communication could be viewed as a threat. But it was silent on standards like recklessness. The court declined to get into that issue, which means as a practical matter right now, under 875C, the intent element remains an open question. Alanas told us that objective is not enough, but it didn't tell us how much subjective is required. And then probably most notable of all, the court did not engage in any First Amendment analysis whatsoever. It decided the case purely as a matter of statutory interpretation, and so the court said it didn't need to address the First Amendment problems. But the point I'll close with is one that Ken White made in the Popat blog, that he nonetheless would expect that the court's discussion of the importance of intent would end up leading into First Amendment cases. So, the basic point is, if it's important to separate intent, or if it's important to separate innocent from bad conduct in general, it would be especially important to do that where free speech interest would be at stake. So in a nutshell, that's what the Alanas case was about, and those are the questions that remain open after Alanas.
Yeah. And Andrew, you had a question for Jonathan about that?
Yeah, I mean, that's a great explanation. And the interesting thing is you described so many particulars and so many unknowns. Would you say that the decision has limited implications or lots of implications for conduct on Facebook or forums and commenting?
I don't know the practical implications for the way that people might use Facebook or Twitter or other social media. I think the most practical impact it will have will be on prosecutors when they decide to bring cases under Section 875C, because it's going to raise their burden. And I think that if prosecutors want to be cautious, and what I mean by cautious is if they want to make sure that their convictions stick, if they do secure convictions against people under that section, I I would doubt that they would be comfortable using a recklessness standard, since the recklessness standard would be the lowest one that the court discussed, and it was also one that the court punted on, saying we're just not going to address that right now. And the reason the court didn't address it, the court has come under some fire for not answering that question definitively. Justice Alito, who concurred in part and dissented in part, among other things, said that the court should have ruled on whether recklessness would satisfy 875C, and said the court confused everybody by not addressing that issue. Justice Thomas, who dissented entirely, said the very same thing. I think that you can defend the court a little bit for not having waded into that, because there is no real circuit split on that issue. In the lower courts, in the courts of appeal, that issue hasn't really been taken up. And normally the Supreme Court does not want to be the first appellate court to review an issue. They want to see how it plays out at the lower courts first, and then they can resolve any conflicts. I think probably the most practical upshot will be it's going to raise the burden of proof for prosecutors, and I think because of the questions they left unanswered, I think it, as a practical matter, could raise it even more, because prosecutors who want to be cautious and protect their convictions, I don't think they would be comfortable arguing for a recklessness standard. And then one other thing I'll mention, just as kind of an aside in response to your question. There has been widely varied response to the opinion, and one of the statements I read a couple of days ago came from the National Center for Victims of Crime, and it issued a statement. It was late Monday, saying essentially that the decision fails to recognize that victims of stalking experience fear regardless of the offender's intent. And said that as a practical matter, what the director of that center really worried about was that if what constitutes a threat is not clearly defined, that organization's concern is that the ruling provides enormous space for stalkers and abusers and other harassers to take action against victims. And then I would add another dimension to that, which would be, in First Amendment law, we talk often about problems of vagueness, that you can find a law that implicates speech as void for vagueness. And the basic concern there is that you have a law that is written so vaguely that you can't quite tell what it prescribes and what it permits. And when you can't quite tell, the normal behavior that people engage in is they steer wide and clear of that line to avoid potential criminal consequences. So I think the concern is, on the one hand, what the Center for Victims of Crime mentioned, that, okay, this could provide enormous space for stalkers and abusers to act. But on the other hand, if you look at it from a free speech perspective, because there is still some uncertainty, it actually, to the extent that people are aware of the opinion, could cause people to steer wide and clear of the line, not wanting to violate one of the federal threat statutes.
Yeah, and Jennifer, what's your take on this kind of ruling and what it might mean for people who are worried about harassment? I mean, do you think this will provide cover for more people harassing online?
As a journalist, I'm curious how that would actually affect. I mean, there is Facebook and Twitter. I'm curious how that would affect comments on articles. There's a lot of harassment that isn't tweets. There is a lot of harassment on Twitter as well. I'm curious how this will really change for most of social media, for journalists, for writers, for creative folks. I mean, I'm curious the practical nature of this ruling and how it would affect day-to-day harassment.
Maeve, I'm curious, at Pew Research, you did a really in-depth research about harassment, just kind of trying to figure out what is out there and what's going on. And found that there was a real prevalence around young women online, with 26% of them being reporting to been stalked, 25% victims of sexual harassment. How do you see things kind of playing out online? I know you guys kind of differentiate between kind of more of the insults that happen online versus the kind of the more serious ones. What have you seen, and how do you see things break down online when it comes to harassment?
Yeah, so when we assessed the data, it became pretty clear early on that there are really two camps of harassment. There's a whole spectrum. First of all, 40% of all internet users have personally experienced online harassment, and there's a certain group that experiences mostly less severe types of harassment, like name calling and embarrassment, and they find this pretty easy to move on from. It's more a layer of nuisance and annoyance rather than any big impact on their life. But for another portion of internet users, and this represents about 18% of internet users, they've had some sort of severe experience with harassment, which includes anything from sexual harassment and stalking to sustained harassment and physical threats. And what we found is that these two groups have different responses and different reactions to their harassment that really differentiate them. And so while it's occurring to a minority of the population, for that minority, it can be a very serious issue.
And did you find any root causes in what you were doing and in your survey? Is part of it anonymity, do you think? Just that people online, there is that kind of freewheeling feeling that you can kind of say anything and do anything without repercussion?
Yeah, so it was interesting because part of the study we tried to assess people's impressions of the online environments that they inhabit or that they observe. And so we asked people to think about their offline versus their online experiences and whether they felt that it was easier to be anonymous online, whether it was easier to be critical of others, and whether it was easier to be supportive. And 92% of respondents said that it was indeed, they thought, easier to be anonymous online than offline. The split for criticism versus support was pretty even. It was about 2/3 of each. So I think that also speaks to this point I made before, that there's really a spectrum of experiences, and anonymity certainly plays into it, especially when you consider the platforms on which online harassment can occur. But on the other hand, there's also a level of support that people find online.
Yeah, that's true. You got to look at kind of both sides of the equation in it. Jennifer, you wrote a really interesting story for Pacific Standard about kind of that women are also found to be harassing women, and you even experienced that yourself. What did you find in that story?
It actually, interestingly enough, it came out of a discussion with other freelance female writers about just putting ourselves out there and finding that we were getting harassment from our women as well. I mean, I know it's pretty well assumed that men harass women online, but from my research, I found a study that came out of London, a London think tank, that women harass women as much as men on Twitter with using rape, slut, or as derogatory as men do. So once I found that study, I sort of talked to more journalists and found that we were all experiencing harassment from both sexes, actually. And I think I wanted to tell the women's perspective, because I think so much of what's heard in the media is that men are harassing women and these men's rights activists, but there actually are women who will take the time to follow and bother and say horrible things to other women as well. So I wanted to highlight that, because I don't think it was talked about, and can be actually more challenging in certain ways, because it's not just calling someone fat and ugly, but it's sort of going after sort of, how you feel as a woman and what you look like and things that are different from men. So men harassers.
Yeah, and how did you personally deal with it when you come up against harassment? I mean, I've had similar experiences covering kind of white supremacists and people finding out I was Jewish, and kind of all kinds of weird emails and things that have came my way, and you wonder, what do you do exactly in those cases? Do you report them? Do you ignore them? I mean, it's always hard to know exactly what to do in those situations.
Totally. In my personal experience, I've chosen to ignore people or block them on Twitter. From my research, I found that most women tend to ignore, and most men tend to engage with their harassers. So a lot of the women I talked to who are journalists just chose to ignore it, even though they would get like onslaught of activity. They just chose to ignore it. So I think that, unfortunately, you have to ignore it, or you can get. The only time I've engaged a troll, it just got worse. So I think it's not. I don't have time in my day to keep engaging with people who obviously want to fight, but it's obviously upsetting when your Twitter feed is full of very upsetting messages.
If I can hop in here,
Yeah,
a related data point that we found, speaking to Jennifer's experience, is twofold. First of all, most people don't actually know the identity of their harasser, so it's either a stranger or somebody whose identity they don't know at all. That applies to about half of people who have been harassed. The other point that Jennifer was saying about how she typically chooses to ignore the harassment is also really a very common response. So about 60% of those who have been harassed ignored their most recent incident with harassment, and the other 40% responded in some way. And what was most interesting was that no matter if people ignored their harassment or decided to respond to it, we asked them how effective they thought their strategy was in resolving the situation, and more than 3/4 of both sides said that they were actually satisfied by the line of action, or inaction, as it were, that they took.
And Andrew, what's your take about just kind of the platforms involved in this? Because we've got, a lot of these things aren't taking place in a vacuum. They're on Facebook, they're on Twitter. They're in what are kind of pseudo-public forums, really private forums, and the companies themselves have ways of dealing with it, and sometimes they're really fallen short. In the case of Twitter, they're trying to strengthen it, but what do you think how do platforms, what's their role in this whole thing?
Yeah, it's really interesting because most of my work is on one of the oldest platforms out there, which is Wikipedia, and it probably is no surprise to most folks that for over a decade they've had this problem of the contributors being 85 to 90% male, and if you look at some of the experiences of females in Wikipedia, it's not a pleasant one. And there are a number of studies that show that women do not like to identify themselves as female in Wikipedia because you quickly get singled out or harassed for things. And this is even pre-Gamergate and pre lots of these issues that have come up recently. One of the tough things about Wikipedia is that it actually encourages productivity through conflict, which is kind of odd, but they encourage people to be bold, to edit first, discuss later, and unfortunately, more often than not, if you publicly identify yourself as a female, very quickly in the conversation, you'll start to see folks, most of them anonymous, bring up things that bring up your gender. So like, you're an extremely stupid woman, or why don't you go back to arranging flowers, or you're feeble, you need another man to stick up for you. And who needs that kind of stuff? So it should be no surprise that we really haven't increased the gender ratio or balanced it over the last 10 years because of this type of dynamic that exists in Wikipedia. If you look at another platform like Pinterest, that equation is completely inverted, right? There's a huge majority of folks who use Pinterest that are female, and I think a lot of that has to do with the fact that most of the interaction there is through a different type of media channel, right? You're sharing pictures, you're liking, you're tagging, you're categorizing. There is not a lot of room for, there's actually not a lot of text interaction there. So it's actually kind of a virtuous circle of contributions that happen there. And Wikipedia is the opposite, where it's mainly text-based. It's very much conflict-based. And unfortunately, those two worlds are completely different.
Yeah. Well, we know Twitter hasn't done a really good job up until recently. They've, hired more people. I mean, what can they do as a platform, do you think, to deal with it? Is it just paying more attention to it, trying to get into the details more? I mean, they're not responsible officially because of, Telecommunications Act. They're not responsible for what people post, but there is some sort of community responsibility. If you run a community and people are running amok, you need to deal with that, right?
Yeah, and one of the tough things is that people experience Twitter differently, right? They allow different clients, there's different ways of interacting with it, and unfortunately the reporting tools of platforms like Facebook and other ones are better than Twitter, right? There's not a lot of nuance in terms of someone on Twitter reporting tweets as being certain categories to alert the Twitter staff. So until they come up with better mechanisms for that, Twitter is still going to be kind of the Wild West compared to more curated platforms like Facebook.
Yeah. Jonathan, what rules? I mean, we've seen a lot of things with free speech come up before on these platforms. What is there something that the platforms have to do to protect themselves? Are they pretty much okay with letting people say what they want? I mean, what's their responsibility under the law, really?
Mostly, they are immunized by Section 230 of the Communications Decency Act for, defamatory comments that could invade somebody's privacy. The gigantic exception in Section 230 is for intellectual property rights. If you are an internet service provider that knowingly hosts somebody else's copyrighted content or allows one of your users to do so, then you can be just as liable as the user that would post that infringing content. I think that a larger issue is the extent to which private internet companies are operating as arbiters of free expression on a global scale. These are things that Rebecca McKinnon has written about persuasively, Jack Balkin at Yale has written about very thoughtfully. The companies are developing what I would characterize as a de facto free speech jurisprudence, which is, I think, a pretty significant development because of the tremendous power of these platforms to shape public discourse. The platforms, I think, are attempting to strike the proper balance among democratic values, legal obligations, and business interests. And the companies have had to make really difficult decisions about complying with local laws that suppress speech or blocking content, to mitigate public harms. A couple of years ago, you remember the Innocence of Muslims controversy that unfolded with YouTube. I think that's a really good case study in the kinds of challenges that platforms face today on a variety of fronts. One of them would certainly be individual harassment. Another one would be threats to national security, and what role does YouTube play in trying to prevent those types of public harms. And in large part, my impression has been, and I've done a good amount of writing in this area in the last year and a half to 2 years, is that these companies are stumbling around a little bit in the dark, and that they are having trouble figuring out how to draw principled lines. If you take Facebook as an example, the former head of their content team, Dave Wilner, at the time that he joined the content team, there were no rules at Facebook regarding what was permissible and what was impermissible on that platform. He began to create the rules himself. By looking for inspiration in, it was the writings of John Stuart Mill and First Amendment theory. He first went to, it was university speech codes, and found them insufficiently specific, so then turned to the writings of John Stuart Mill, First Amendment theory, and then got so frustrated he did what we all do when we get frustrated, and he just hired a consulting firm to do it for him. And they created a manual that was leaked to Gawker, and then Gawker and everybody else widely ridiculed it. So, I mentioned that as kind of a vignette that I think these companies are really well-meaning in attempting to create spaces that are good places for people to engage in constructive and thoughtful discussions, to contribute to discourse, the public discourse. But at the same time, too often, I think these companies are making decisions. They're free to set and enforce these rules at their pleasure without providing the due process for users that would typically bind at least a democratic country when it would make a decision affecting the fundamental rights of their citizens, including the rights of freedom of speech and press. I would like to see these companies be a little bit more transparent about some of their content moderation processes, their curation processes, and just simply tell us as users, what kinds of rights do you owe us? Your rights in the soft sense, not the hard sense.
Right. Jennifer, I'm curious, have you seen any communities that you see as kind of models when it comes to dealing with moderation and harassment? I mean, Andrew mentioned Pinterest being a little bit better, but have you noticed any that you think are better or worse?
I will say, I've written for Pacific Standard, and they don't allow any commenting on any of their articles, which I found very refreshing as a journalist, because I knew, I was like, someone's going to have something to say about what I've written about, but there was nothing to combat, really, and that was a nice feature. Most sites, unfortunately, don't, have rampant comments, especially it's popular. The perspective I came from was that a lot of women write first-person essays, which are super popular online, and therefore they get a lot of comments, harassment, and I think it opens yourself up in a way that, if you were just writing a story about what's going on in the news today, that you probably wouldn't get that sort of harassment. So I think, on one hand, it's really nice not to deal with comments. I think a lot of writers really appreciate that. On the other hand, most sites do have a very popular comment section. BuzzFeed, for instance, and when I wrote for them, I had, within 2 hours, had 700 comments. And so it drives a lot of traffic for sites, and I understand why it's part of the discussion. It's just, it can be a little bit challenging to navigate those waters when there's really there's not an editor sitting there going through all those comments.
Yeah, and different sites do it differently. We've covered a lot around online comments before. Maeve, did you want to jump in about what's happening in online comments now?
Well, yeah, so to bring it back a little bit more broadly to this question of should companies be responsible for regulating the harassment that is happening on their sites, something that we found in our report is that most people who decide to respond to their harassment take just one step, and it's typically a step that they can do pretty painlessly on the platform on which harassment's happening. So they confront the person online, they unfriend or block somebody, they change their username or password, they discuss the problem on forums to sort of gin up support for themselves. So these sort of digital actions that people can take that are relatively easy are actually some of the most popular actions. Going to law enforcement, for instance, only 5% of people did that, and just 8% stopped attending offline events. So whether this is because people don't have a well-informed or capable law enforcement to turn to right now, and so they mostly keep to themselves online and try to solve the problem by themselves, we can't really say, but we certainly did find that people are taking actions, and they're online actions.
Yeah. Thanks a lot for the discussion. It's an important discussion, and it's one that I think we'll continue to have as things change and morph online. So I want to thank our panel, Andrew Lee from American University, Jennifer Chen, freelance journalist in LA, Jonathan Peters at University of Kansas, Maeve Duggan at Pew Research Center, and our producer, Jefferson Yen. You can catch the Mediatwits each and every Friday at mediashift.org. Thanks, everyone, and have a great weekend.